Good morning, friends. It is heartening to note that the National Green Tribunal chairperson, retired Justice A.K. Goyal, has given a notice to the Government of India, to the Government of AP, to the Chief Secretaries, all these things. So, taking explanation about the negligence or the root causes for the gas leakage in Visakhapatnam, the incident. So, from the LG Polymers. Moreover, the Green Tribunal has directed the company LG Polymers to deposit 50 crores of rupees with the district magistrate, that means with the district collector, as absolute liability principle. Right, we will discuss the principle later. So they directed the LG Polymers to deposit 50 crores. Right, okay, the inquiry will be conducted. They have constituted a high-level committee consisting of 5 members, out of whom retired Justice D. Seshasena Reddy will head the chamber. Because you all know that Mr. Seshasena Reddy previously worked as the district judge of Prakasham district also. He is a retired judge of the AP High Court. Under him, the Andhra University, previous ex-former University Vice Chancellor, and some other professors, head of NEERI, AP Pollution Control Board people, all the people, they were made as members, and they were given 1 month time to decide the issue. Of course, the terms of references and all. So in this case, the main thing is, while disclosing the order, the National Green Tribunal says that styrene is decided as a hazardous gas. So when you are dealing with, when the company is dealing with hazardous, inflammable and combustible substances, they should be more careful. They should not do anything which is affecting the environmental pollution. So the result of the gas leakage is one such. Therefore, as per the strict liability, you are liable, and therefore you pay that 50 crores or things they have decided. But here the thing is, so once again I am reminded of the law of torts, the principle of the so-called strict liability and the advanced absolute liability of India. Now let us discuss those cases. Let us have a quick cursory glance toward the cases. So you remember in 1868 the famous case of Rylands versus Fletcher. Rylands versus Fletcher, 1868. So this is the case in which Blackburn J. he has proposed the theory of strict liability. Strict liability means even though you are not at wrong, you are liable to pay because there is some incident. So in that case, I have told you that the defendant he has constructed artificial lakes, a reservoir in his previous coal mine, but it was entrusted to an independent contractor. Somehow, since there was gaps which were not filled up, and the water entered the neighboring field of Rylands and it damaged his coal mine. In that connection, the principle of strict liability with 3 principles. Number 1, you may be knowing, number 1 is dangerous thing. So when a dangerous thing, here water has become a danger, when a dangerous thing escapes. Second is escape. So you should be more careful about the dangerous thing. The water became dangerous because of the disused shafts, or previously there is a coal mine and they have dug deep into the matter, and I need not explain you all these things, escape of thing. And third, when you are using the land, non-natural use of the land, this principle also I have told you. In that, please remember the basic principle in the law of torts. I tell you, sic utilito ut olinium, that means enjoy your own property without injuring the others. Right? Of course, there are certain exceptions, general exceptions for this legal principle. You may be knowing, they are number 1, that is plaintiff's own default, or plaintiff's own default. That is, you heard the case of Ponting versus Noakes, 1849. Oh, when the plaintiffs, that is Ponting's horse, went to the Nook's land where there were certain poisonous plants. So the horse nibbled the poisonous leaves of the tree and died. But here, what is that? It is a general defense because it is the default or defect on the part of the plaintiff. He has not disposed any, dangerous things are there or poisonous trees are there or animals not allowed. Like if he has erected a boat, he would have been saved. So therefore, he has taken the so-called exception. Second is plaintiff's consent. Certain times the plaintiff may consent. So here this Carstairs versus Taylor, 1871. The Carstairs plaintiff, he hired the ground floor. Of course, the owner and the defendant, both of them are same. They occupied the upper floor and the water stored in the upper floor leaked without negligence of the defendant. Somehow they leaked and actually they have injured the goods of the plaintiff. Of course, the defendant cannot be held liable because knowing all the situation, the plaintiff undertook that he will stay in the house for rent. And act of God, you might have seen the film Gopala Gopala, best example, and Nicholas versus Marshall, 1876. So just like the Rylands and versus case, so artificial lakes were constructed, but due to the incessant rain, then the continuous downpour of rain, there was inundation and therefore there was a breach and the nearby bridge was washed away and the lands were damaged. Of course, due to the act of God, nobody can do anything. So this is an exception for the rule of strict liability. And act of third party, this is also another exception. Richards versus Lothian's 1913 case. So what happened is actually the municipality, they have allowed the water to be flown to certain, they have actually opened the pipe, it has to come to the parties. But somebody, he has blocked the waste pipes of a wash basin, due to which there was a burst and the overflowing water damaged some of the goods of the plaintiff. But the municipality, Lothians represent, we cannot be held liable because they have taken all precautions, but somebody has obstructed the top of a certain wash basin. And statutory authority, so Green versus Chelsea Water versus 1894 or Nagireddy versus State of AP. So statutory authority, when the government is authorized to do certain damage, then you can't claim any compensation from him. So supplying water by pipes without negligence, water pipe broke. So this is also another municipality case. When the so-called pipe broke, normally they wanted compensation. But because municipality is authorized, you cannot get compensation. And now coming to the principle of absolute liability coined by Justice P.N. Bhagavati in the famous case of William gas leakage 1985. Friends, here it is pertinent to note that even though the Bhopal gas disaster took place in the 1984, the first case, and the Volium gas incident took place in the year 1985, the first case decided was Volium gas leakage case, and this is basing on the absolute liability. So strict liability is an age-old 1868 liability. So Justice P.N. Bhagavati coined this latest absolute liability. According to this, a person could be held guilty even if there was no intention to commit a crime. The difference between strict and absolute liability is whether the defense of mistake of fact or act of God, all these available or not. Here, in a case of absolute liability, no defense will be accepted. Therefore, absolute liability will be stronger than strict liability. And of course, some of the lawyers say by mistake that strict liability would have been printed. It should have been absolute liability. Anyway, the time has come for us to discuss the law of torts and this liability basing on the direction given by the National Green Tribunal. So, with the direction of the National Green Tribunal only, we have once again to recapitulate our lot of torts, very famous Rylands versus Fletcher case and also William gas leakage case yesterday we discussed. Thank you.